Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law number 2. You've been asked to come to this court this morning for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are referred to as your more serious type offenses, whereas your misdemeanors are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, your felony offenses are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. The person is convicted of a first degree felony. The range of punishment is minimum 5 years, to maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those punishments because, as I mentioned to you earlier, the case that you have in this court is a misdemeanor case. Misdemeanor cases are divided into 3 categories. We'll start at the top and work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, if a person is convicted of a class C misdemeanor, the range of punishment is by fine only. That is, the fine cannot go no higher or cannot exceed $500. Now, your misdemeanor cases are cases that start in the city court or the JP court, and they come to this court when a person is convicted in the city court or the JP court. And then the case comes here. For example, not wearing a seatbelt is a class C misdemeanor. Speeding is a class C misdemeanor. So those cases come here when they appealed from the JP court or the city court. And when it comes here, the fine does not change. It's still the same. In essence, if you're found guilty, you cannot be assessed a fine no more than $500. Okay, you cannot be given jail time. However, if you fail to pay the fine, or if your fine was converted to community service because you could not pay the fine, and you fail to perform the community service, then the court can issue a warrant for your arrest. We call that a capious pro fine, so that you can either pay the fine or sit the fine out in jail. And every day that you sit the fine out in jail, you'll be credited $100 per day that will go toward your fine and court costs. Now, the next highest misdemeanor is a class B misdemeanor. For the class B misdemeanor, the range of punishment is minimum of 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both confinement and a fine. That means jail time and a fine. The highest misdemeanor is a class A misdemeanor. Range of punishment is minimum of 0 days to a maximum of 365 days, which is 1 year in the county jail. Or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation that a person can get. They can get one or the other. You can either get regular probation, we call that straight probation. It's normally referred to as adjudicated probation. The reason why they call it adjudicated probation, because you will have a conviction on your record if you get that type of probation. However, there's something that's called judicial clemency, where the court or the judge can set the conviction aside, which means you will no longer have a conviction. That's called judicial clemency. Now, in order for that to happen, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on probation. And three, you have to be successfully discharged off the probation by the probation officer. If those three things happen, then the court has the discretion to set the conviction aside, and you will no longer have a conviction. Now, if you get another conviction later on, then the conviction that you receive discretion from the judge on, that is judicial clemency, or the one that was set aside, then what will happen is if you get a new conviction, then the case that you receive judicial clemency on can be brought back up, resurrected, revived, and it can be used against you. And if you're trying to get a license with Child Protective Services or CPS, they can deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, if you have, if you're given deferred probation, or which is called unadjudicated probation, it does not result in a conviction or record, which is successfully completed, the case will be dismissed, and you may qualify for non-disclosure. A non-disclosure basically means that your record on this case will be sealed. That is to the general public. So the general public cannot have access to the fact, to your record that shows that you was on deferred probation for it, if you get a non-disclosure. Now, if you violate your probation, then your probation will be revoked. And if your probation is revoked, you can get a conviction. All right. Now, the paperwork that you have on the clipboard, okay, everyone that's here for a case should have a clipboard. Who does not have a clipboard? Raise your right hand. Okay, everybody has a clipboard. Okay. Now, this is what I'm going to do. I'm going to go over that paperwork with you. The first document is titled Judge's Explanation of Rights of Defendants Without an Attorney. Now, everybody in here would have to fill out that document. All right. And this document basically says that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. So it's talking about your rights as an attorney, to have an attorney. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you by the court. Okay. Number three, you may represent yourself. That is, if you want to give up your right or waive your right to have an attorney, you can represent yourself. Now, the first paragraph states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial affidavit or financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is another document on that clipboard. It's a 3-page document that is titled Jefferson County Affidavit of Indians. And I need everyone to turn to that right now, because on that document, what you would have to do, you will fill out the first page, all right? And then we go to the second page. But you go to the second page, and at the top of the second page, it'll have defendant's oath. You fill out that section. And then on the second page of that document, it'll have unsworn declaration near the bottom. You fill out that and then you stop. All right. So let's go back to the Judge's Explanation of Rights to Defendants Without an Attorney. Now, as I mentioned to you earlier, If you have enough money, you can hire an attorney. If you don't have enough money, you want an attorney, you can ask that attorney, a court-appointed attorney be appointed to represent you, but you must first answer your question. And then the third paragraph basically is for people who would like to waive or give up their rights to have an attorney, and they want to represent themselves. If you represent yourself, that means you're acting as your own lawyer. If you're acting as your own lawyer, then you'll have an opportunity to talk to one of the two prosecutors or assistant criminal district attorneys from the Jefferson County District Attorney's Office to see whether or not you can work out a plea bargain or a settlement. That's what a plea bargain is, the way to settle your case. All right. Now, that paragraph states that you cannot talk to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. The waiver is another document, it's probably the second document on that clipboard that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Now, this is only for people who will be waiving their right to an attorney and representing themselves. You'll have to read this document and then sign your name on the line that's titled defendant and dated today's date. Now, let me go back to the first document. The big paragraph here on this first document. That paragraph states that you should be aware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, that last paragraph states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you by the court. All right. Now, at the bottom of that document, there's 5 lines to the left. Okay? If you would like to hire your own attorney, you will place your initials on the first line to the left. Okay? If you've already hired an attorney to represent you, you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney or give up your right to have an attorney represent yourself, well, let me back up. If you would like to request that an attorney be appointed to represent you, you'll put your initials on the third line to the left. If you've already been appointed a court-appointed attorney, you put your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines to the left at the bottom, you will sign your name on the line that is titled defendant, and you will date it today's date, December 17th of 2024. All right. Everybody understand? Okay, now I'll just simplify it again. If you just want to hire your own attorney, this is the only document you don't sign. All right? Put your initials on the line to the first line at the bottom at the left. Sign it and date it. That's it. You don't have to do it anymore. For people who hire their own attorney, you're only going to sign one document. If you want to apply for a court-appointed attorney, you will sign 2 documents. It's this document that everybody's going to sign. Your initials is going to be on the third line to the left, and you will sign this document that is titled Jefferson County Affidavit of Interest. You will fill out the first page, top of the second page that says defendant's oath, and the middle part of the second page that says unsworn declaration. And then you'll stop. If you want to represent yourself, obviously you sign it the same document that everybody signs, the first document. Your initials is going to be on the line at the bottom line to the left. And then you're going to sign it and date it December 17th, 2024. And then you will sign this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You will fill out this document, you will read this document and then sign on the line that says defendant, dated today's date, defendant, December 17th. Everyone understand? Do you have any questions?
Yes, sir.
Okay, no questions. All right. Now, the next right that you have as a defendant in a criminal case is a right to have a trial by jury. The jury sits over here, and we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in the case. They'll listen to all of the evidence. They will listen to the arguments of the attorneys, and then they will go into the jury room and deliberate, and then they will decide whether to find you not guilty or guilty of your choice. Now, you can waive or give up your right to have a jury trial. If you waive or give up the right to have a jury trial, that means you will not be having a jury trial. Your case will come before the judge in one of 3 ways. One way to come before the judge is by way of a bench trial. That is a trial by judge only, where the judge is the judge and the jury in the case. The judge will listen to the evidence. The judge will listen to the arguments of the attorneys. The judge will apply the law to the facts, and then the judge will decide whether to find you not guilty or guilty. Now, the other way that your case can come before the court is by way of an agreed plea bargain agreement. Okay? As I mentioned to you earlier, the plea bargain agreement is where you and the state of Texas work out an agreement to settle your case. Okay? That comes before the judge. And the judge could do one of 2 things. The judge can accept your plea bargain agreement or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you can tell the judge, well, judge, since you are rejecting my plea bargain agreement that I made with the state, I take my plea back. In essence, judge, I'm not pleading guilty to this charge, or I'm not pleading no contest. Guilty means that you tell the court that you committed the offense that you've been charged with. No contest means that you're not fighting the charge. So you're telling the judge, I'm not pleading, since you're not accepting the plea bargain agreement that I made with the state, I take my plea back. You have a right to do it. All right. Now, if the judge does follow the plea bargain agreement, and you say within 30 days, you decide, hey, you know what? I want to appeal this case because I think I've been wrongfully convicted or the court committed an error by convicting me. If you want to appeal, after the judge has followed the plea bargain agreement, you need to get the judge's permission. Now, if the judge gives you permission to appeal, your case is going to leave this court and go right upstairs to the 9th Court of Appeals. We have 4 judges up there. They will review the case. They will decide whether to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or if they deny your appeal, then they can send the case back down to this court or to this court to give you a whole new trial. Or if they deny your appeal, your case you can appeal it to a higher court than them. That is, you can appeal it to the highest criminal court in the state of Texas. And that court is the Texas Court of Criminal Appeals. You'll have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means you're representing yourself and you'll petition the court to review your case to see, one, whether or not your appeal should be granted or whether or not this court committed an error by convicting you or whether or not you were wrongfully convicted. Then they can do one of 2 things. They can grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. If they deny, well, they can send the case back down to this court to order this court to give you a whole new trial, or they can send it back up to the 9th Court of Appeals or with orders from their court. All right. Now, the other way your case can come before the court is by way of an unagreed plea bargain agreement. Unagreed means that you and the state have not been able to reach an agreement. You talk to them, state say, well, they want to give you 40 days in jail. You say, well, I'm not taking 40 days in jail. I want the judge to decide my jail time. We call that an unagreed plea bargain agreement. So the case comes before the judge, and the judge can assess punishment anywhere within the punishment range. If you're in class B, the judge can give you anywhere from 0 days to 180 days jail, or the judge can give you probation, either deferred or straight probation. Or he can give you, he'll just give you a fine, or he can give you a fine and jail time. So those are the things that the court can do, all right? That's called an unagreed plea bargaining agreement. When it comes before the court, the judge decides what the punishment is gonna be. Now, the other right that you have is a right to have witnesses that come to court. They sit in that chair over there that I'm pointing at that has the microphone in front of it. And what witnesses do, they can testify for you or against you. If you're representing yourself, you can ask some questions. If you have a lawyer representing you, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses, which means that you will not be calling witnesses in court on your trial. Now, it does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. You also have what is called a Fifth Amendment right against self-incrimination. I know a lot of times we watch these television shows about law and order, and you see somebody on the witness stand, they ask them, I take the fifth. Or if the police comes up to them and talk to them and say, I take the fifth. That means that I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying nothing. Okay? You have a right not to say anything. State can't force you to take the witness stand, and the government can't force you to take the witness stand, because the Fifth Amendment of the United States Constitution gives you that right to remain silent. Okay? So now you can waive or give up your Fifth Amendment right against self-incrimination. If you waive or give up your Fifth Amendment right against self-incrimination, that means that you will be taking the witness stand. Okay? Now you also have a right to have what is called discovery. Discovery means that you have a right to see what's in the state's file, or discover what the evidence is that the state has against you. You have a right to have access to that. We call that discovery. And also you have a right to see police reports. You have a right to see your statements, witness statements, lab reports. You have a right to see photographs. You have a right to listen to audio recordings, see video recordings, see documents, instruments, whatever they have, whatever evidence they have, you have a right to have access to that. Now, you can waive or give up your right to have discovery, which means that you will not be having access to the evidence that the state has against you. Okay. Now, as a defendant, well, everyone that's here who is a defendant in a criminal case, you've been arrested, you've been charged, arrested, you've been spent time in jail, you bonded out, and you're out of jail either on a cash bond, a surety bond, or a PR or personal recognizance bond. Cash bond means you pay the full amount to get out of jail. Surety bond means you pay the bond, a percentage of the bond to get out of jail. PR bond or personal recognizance bond means that you didn't have to pay any money to get out of jail. You were just released on your own personal recognizance. I said that to say this. Every day that you spent in jail can be used as credit towards your punishment. Now, no, I said every day. So for example, let's say you were arrested at 11, no, you were booked in jail at 11:59 p.m. last night. You got out of jail at 12:01 a.m. this morning. Then you got out of jail 2 minutes later. 59, well, I said 12:01, or 2 minutes later. Guess what? That's 2 days. It's 2 different days. Okay? And so that's how it's calculated. It's not by 24 hours. It's 2 different days. So every day that you spent in jail, it's credited toward your punishment. So for example, let's say you and the state have reached a plea bargaining agreement, and you spent 5 days in jail before you bonded out, and the state offered you 5 days to serve in jail. That means you don't have to serve any more time in jail, because you've already served 5 days in jail. Therefore, you get credit for the time that you have already served. Now, if they're asking for 7 days in jail, you serve 5 days in jail, we will simply subtract 5 of 7 that you used to. So you don't have to do 2 days in jail. All right? And so every day that you spent in jail also is credited as $100 per day that will go towards your fine and court costs. So if the state is offering you fine and court costs of $500, you spent 5 days in jail, that's $500. You don't have to pay anything because it will be taxed and retired, because the time that you spent in jail has already paid it. Now, if they're offering fine and court costs of $700, you spent 5 days in jail, we will subtract $500 from the $700, that leaves $200. That means you would have to pay $200 on the day that you dispose of your case. Now, if you cannot pay it, no problem, because the law allows the court to put you on a payment plan. You can be placed on a payment plan. You can pay off so much each month until it's paid off. But sometimes our money, we may not have the money because of our we may not have a job, or we may not have the income. No problem. If you don't have the money, to be put on a payment plan, then what we can do, we can convert your fine and court costs to community service. So for every 1 hour community service that you perform in a nonprofit organization, $12.50 will be credited toward your fine and court costs. So for example, if you work 8 hours one day, that's $100 that goes toward your fine and court costs. So in our scenario, your $200, just work 2 8-hour days, that's it. Yeah, that's $200, and so you pay off your fine and court costs, 2 days of work. Okay. Now, Jefferson County has a program that is called pretrial diversion for first-time offenders. If you have not been in trouble before, with this program, they will dismiss your case. And if you successfully complete the program, they will, you can get it expunged from your record. Expunged means wiped off, like it never happened. Okay? In order to qualify for the program, you have to have, it has to be first time getting in trouble. You have to have an attorney to help you to get into, do the application. And then the third thing is, it cannot be an offense for unlawful carrying a weapon or resisting arrest. For all other offenses, you may qualify. Now, if you're a veteran of any one of the branches of the United States military, Jefferson County, when I say Jefferson County, I'm talking about the district attorney's office. They have a program that is called Veterans Court. And with the Veterans Court, the only thing you have to do to get in that program is to be a veteran. And what they will do is you get into the program, complete the program, to dismiss the case, then you can get a non-disclosure. Non-disclosure, as I mentioned to you a little earlier, is where the record is sealed to the general public. Okay? Notice I say general public. General public means that the general public can't have access, but the government can. But most of the public is the general public, so most of the public cannot have access to your record if you are in that program and you get a non-disclosure. All right. Now, this court, County Court at Law Number 2, is a program that was started in 2017. It was a program, best way to put it, I mean, I didn't come up with it. God gave it to me. Okay? It was all about what God laid on my heart. And with this program was designed to address the issue of what we call recidivism. Recidivism just basically means that a person commits crimes over and over. And with that program, we have partnerships in our community. One of the partnerships that we have is Spindletop. And we have Deputy Hinton, who's here from Spindletop. He's going to come to you a little later and tell you more about that program. But basically, the program that God gave to us in March of 2017 is a program where Spindletop, who is our local mental health authority in the Jefferson County and the Southeast Texas region, they have the expertise to address mental health issues that individuals may have. For example, you do not have to be incompetent or insane to participate in the program. You can just merely suffer from anxiety, or depression, or any other host of mental illnesses, and they have the expertise to address your mental health needs. Now, what Spindletop will do, they would first of all conduct a private interview, either in our jury room, at their facilities, or by phone, whichever is convenient for you. And then they will do an assessment, develop a treatment plan for either outpatient or inpatient, depending on what your mental health needs are. If you have issues with drugs and alcohol, what Spindletop has a program that is called ATAR. ATAR is ATAR. It's an acronym that stands for Addiction, Treatment, and Recovery. We have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. What they will do, they will first have a screening, do an assessment, and develop a treatment plan for either outpatient or inpatient treatment. Now, if you're unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center that has a program that is called, they have a partnership with Lamar University, and Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school or you have not received the GED, graduate equivalency diploma, they have a GED program. Now, all these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes because they have too much to lose. And so I like to say that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And the other benefit about the program is that all of these programs can be used as community service. So for example, let's say you was ordered to pay a fine and court cost, but you could not pay the fine and court cost. And we converted your fine and court cost to community service. So every hour that you might be in Spindletop in counseling, or in job training, or in GED class, or in drug and alcohol counseling, $12.50 will go toward the payment of your fine. 1 hour will go toward community service, and the other thing, you'll be in the program. So I like to say that you're killing 3 birds with 1 stone. You're in the program, you have community service, and you're paying your fine and court costs. Now, if you're interested in any one of these programs, we have some brochures that we can give to you to get started in these programs. And as I mentioned to you earlier, this program, which the Lord laid on my heart and told me that this is what we need in this county. And so we presented it. And so hundreds of people have been helped. And who knows, you could be the next one. So at this time, as I mentioned to you earlier, we have Deputy Hinton. Deputy Hinton is going to come before you and tell you a little bit more about the program that Spindletop has to offer. Deputy Hinton.
Thank you, Your Honor. Good morning. Again, my name is Steve Hinton, Mental Health Deputy, State Commission Chair of the Sheriff's Department. The reason I am here today in this courtroom is because the judge does care about every single person that comes before the bench. So if the judge has found, which statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation. And maybe this is your first time to be in court, could be your 5th time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us. And this morning, when you came in, I gave each of y'all one of these documents here, and this is gonna be a way for you to share that need with me very privately. The only one's gonna see this is me and a couple other qualified mental health professionals who work for the team. We will be reaching out to you, whatever you put down in here as far as resources that you feel that you may need, or you just want to talk about it to see if this is something that would be applicable to your particular situation. We'd be glad to visit with you, discuss this in further detail. Now, also, one of the first resources I want to be able to give you here today is this card here. It has a 1-800 number on there. If you ever find yourself in an unsafe place, you can call that number and get help immediately. And I'll get this to everyone here before we leave. This court's going to move very rapidly. In the meantime, eventually it's going to go into recess. When it does, I'll come out there, I'll visit with you, I'll pick up those documents from you, I'll answer any questions you have. I'll be giving this to you at that particular time. Thank you. Thank you, Ron.
Okay, thank you, Deputy Ann. Now, ladies and gentlemen, we're gonna be going into recess in just a few minutes. But before we go into recess, I need to, inform you that it's gonna take us a little time to, go through the paperwork that you fill out. So make sure you fill out the paperwork. If you need help with the paperwork, we have our court personnel who's here, who will be, happy to help you with filling out the paperwork. Now, it's gonna take a little time for us to pick up the paperwork from everybody and evaluate it. And so if you need to use the restroom, there are 2 restrooms right out in the hallway. We have the male restroom, or men's restroom, right in front of County Court at Law number 3. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. Now, you'll be allowed to use the restroom, and then once you come back in the courtroom, do not leave the courthouse. Leave the courthouse, your name is called, and you're not here, then your bond can be forfeited. That simply means that your bond is forfeited, or a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail, and then we have to go through this process all over again. Now, once y'all finish filling out the paperwork, and once we finish evaluating the paperwork, we're gonna ask that you come before the bench, one at a time. You're gonna stand right here. And, either, we're gonna put you in one of 3 categories. Either you wanna hire an attorney, want a court-appointed attorney, or you wanna represent yourself, okay? Do we have any questions? Okay, no questions? Again, if you need any help with your paperwork, just let us know. And we have our court personnel. I'll be also helping as well if you need some help with your paperwork. But at this time, the court will be in recess, and make sure we continue to be orderly, because even though we're in recess, we still airing on YouTube and all that, okay? So at this time, the court will be in recess. And Mr. Watkins, just hold on a minute. We're going to get your case reset. Just hold
Okay.
on. All right, you can put your mic back on mute.
Yes, sir.
Mr. Watkins?
Yes, sir.
Okay, your case will be reset to February 4th of 2025. On that day,
Okay.
you need to be here in court in person.
Yes, sir.
Okay, so you are, if we start at 9 a.m., February 4th of 2025, you're free to go and you have a blessed day.
All right, you too.
Thank you.
February 4th, 2020.
with the arraignment docket. When I call your name, please come before the bench. First case is cause number 24 CCCR 2226. Case is style of state of Texas versus Arterius Holman. Mr. Holman, your full name is Arterius Holman? Okay, Mr. Holman, would you please raise your right hand? Mr. Holman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Okay, Mr. Holman, you may put your hand down. How are you doing, Mr. Holman? I'm doing fine, thanks for asking. Your full name is Terrence Quentin Holman, is that correct? Now, Mr. Holman, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Mr. Holman, do you recognize this document? And is this are these your initials on the line that's titled that states you'd like to have your case reset to hire your own attorney? And is this your signature on the line that is titled defendant? Mr. Holman, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Holman, your case is going to be reset to give you an opportunity to hire an attorney. When have a seat in that first chair on the wall and wait for your name to be called. Need those other 3 cases that I gave you earlier. Your phone went off while you were Okay, next case is cause number 24 CCCR 1108. Case is style of the state of Texas versus Christopher Jefferson. Mr. Jefferson, your full name is Christopher Jefferson?
Christopher Lee Jefferson.
Okay, how are you doing, Mr. Jefferson?
Pretty good. And you?
I'm doing fine, thanks for asking. Mr. Jefferson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes,
Now, Mr. Jefferson, before you sign this document, did you read the document?
yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Jefferson, your case is going to be reset to give you an opportunity to hire an attorney. Mr. Jefferson, just have a seat in that second chair on the wall. Oh, yours is ready. You free to go.
January 31st.
That door is locked, Mr. Jefferson. That door on that side is locked. DeMarcus Lewis, DeMarcus Devon Lewis. Mr. Lewis, your full name is DeMarcus Devon Lewis.
Yes, sir.
Okay, how you doing, Mr. Lewis?
I'm all right about yourself.
I'm doing fine, thanks for asking, Mr. Lewis. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to have your case reset? Well, it states that you have already hired an attorney, James Patchett.
Yes, sir.
Mr. Lewis, before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Lewis, your case is going to be reset to give your attorney an opportunity to send his letter of representation in, but before your case is reset, the bailiff is going to hang you some bond conditions. And I'm going to go over these bond conditions with you. And these bond conditions state standard bond conditions in County Court at Law Number 2, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number one, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number four does not apply, it only applies in a DWI case. Your case is not a DWI case. However, condition number five does apply. And condition number five states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Lewis, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, Mr. Lewis, you're gonna stand in front of the court coordinator. Your case has been reset. Once you get your reset from the court coordinator, you'll be free to go, and you have a blessed day.
Yes, sir. I'm used to it. I stand on 12 hours a day.
That's October 31st.
Did you already reset, Christopher Jefferson? Yeah.
Oh, yes.
He's gone? Or do you still have the paperwork?
I'll give it back to you.
Okay. No.
Those three back.
Christopher Jefferson?
Probably call the same.
Okay, well,
You didn't give me back his paperwork.
here it is right
Oh,
here.
yeah.
It was sitting up there. Okay,
And then we were set Mary, right? Huh? Here. Here.
Jamarlin Quibido? You please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
Good.
I'm doing fine, thanks for asking. Your full name is Jamarlin Brooke Quibido? Oh, Jamelin?
Yeah.
Okay, Jamelin, Brooke Quibido. Now, I have before me a document that is titled, well, first of all, how are you doing?
Good.
I'm
good. How are you?
Okay. Now, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the
Yes,
best of
sir.
your knowledge? Okay, I read your answers. Your case is going to be reset. You're gonna stand in front of the court coordinator. She's gonna reset your case. Once your case is reset, you're free to go and you have a blessed day.
Yes, sir. You too.
All right. Bradley Blunt. Let's see. If you want to sit down, you can. You don't have to stand up.
It's okay.
Okay. This is cause number 24 CCCR 2590. Case is style of the state of Texas versus Bradley Blunt.
Yeah.
Let's see. Bradley Michael Blunt. How are you doing, Mr. Blunt?
Very good, sir.
That's good. Now, Mr. Blunt, Would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Blunt, I have before me, well, before we get started, you have a right to have a court reporter to type down everything that's being said in the court in your case. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right for a court reporter?
Yes.
Okay, Mr. Blunt. I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
Or are these your initials on the line that state you would like to waive your right to an attorney
Yes.
and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Mr. Blunt, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Mr. Blunt, I have a document on my computer that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Blunt, it alleges that you, Bradley Michael Blunt, on or about September 17th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Mr. Blunt, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Blunt, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishment. Is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are two sets of initials. First set of initials is the lower paragraph that is titled Waivers, and it is next to a line that's titled Guilty. Did you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Blunt, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Blunt, are you a citizen of the United States?
Yes, sir.
State offers states one.
Now, Mr. Blunt, the state is offering State's Exhibit Number 1 to be used as evidence against you in this case. State's Exhibit Number 1 is the first document that you acknowledge. This is misdemeanor plea admonishment, State's Exhibit Number 1. This is the same document that have your initials in these two locations on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. Blunt, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Mr. Blunt, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state is offering 90 days in the Jefferson County Jail probated over 1 year, $300 fine, 3 hours of community service plus court costs.
Okay, now, let's see. Let's get entry. What is the court cost? Mr. Blunt, the state is offering that you serve 90 days in Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. Be required to pay a probation fee of $6 a month, year license fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $136 a month. Will you be able to pay the $136 each month?
Figure it out.
Well, now let me tell you this here, Mr. Blunt. Now, when we ask the question, can you pay it? Whatever your answer is, if you say no, that's not gonna change the arrangements that you have made with the state, okay? Because sometimes people think, oh, I gotta pay it. Now, if you can't pay it, you just need to tell us, because the law allows the court or the judge to make adjustments. Now, you remember when I was talking to you all on doing arraignment? And I said, if a person can't pay the fine and court costs, we can convert it to community service or something like that. So the court, the law allows the judge to do that. Okay? So when you say you're gonna figure it out, that indicates to me that you probably can't pay it. Okay? Okay, now just all, you just have to be truthful. Okay, if you can't pay it, that's all I need to know, and then we'll figure it out. Okay?
Okay, I'm on a fixed income.
Okay, good. That's what I need to know.
It'll be hard, but
Okay, let's, is there an affidavit in the,
No.
okay, what we're gonna do, we're gonna give you, the bailiff is gonna give you a document. It's titled, Jefferson County Affidavit of Injury. And what you're going to do is fill out that financial part, write your name on the file. That gives me information that I can use to make a determination whether or not you're indigent. And if you're indigent, then we'll go from there. Okay? So we're gonna have you to take us, just go over to that table right here, and she's gonna bring you the paperwork, and you can fill that paperwork out, and when you finish, we're gonna bring you back up. Okay?
thank you, Ron.
Okay, you're welcome. I know, but I'm not gonna do John well right now. Because his is not gonna take long. I could do this one a lot faster. Is that Elijah Lewis? Good morning. Now, did I pronounce your name right?
Yes, you did.
Oh, oh, wow. All right. Now, Ms. Lewis, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Lewis, you may put your hand down. How are you doing, Ms. Lewis?
I'm good, how are you?
I'm doing fine, thanks for asking. Now, Ms. Lewis, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Or these your initials on the line that state you like to apply for court-appointed attorney?
Yes.
I have another document here that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Ms. Lewis, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Laurie Perazzo. Attorney Perazzo will be given information to contact you. You will be given information to contact her, and our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you, have a good one.
All right, same to you. You have a blessed day. There you go. Maisha Mercadale. Ms. Mercadale, your full name is Maisha M. Mercadale. Ms. Mercadale, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing?
Good.
I'm doing fine, thanks for asking. Ms. Mercadale, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's instead of initial, well, there's a signature on the line that's titled Defendant Signature. Is that your signature? Ms. Mercadale, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Mercadale, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will give information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that second chair on the wall. Mr. Blount, are you finished?
No, sir.
Oh, you just have to fill out the first page. The financial part.
Just gotta do some math.
Oh, okay. Kevin Johnwell. This is cause number 24-CCCR 2678. Case is style of state of Texas versus Kevin John Well. Kevin Gerard John Well.
Yes, sir.
Mr. John Well, is that your full name?
Yes, sir.
Mr. John Well, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. John Well, you may put your hand down. How are you doing, Mr. John Well?
I'm good and you.
I'm doing fine, thanks for asking. Mr. John Well, I have before me a document, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials online that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of entering guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. John, Well, before you sign and initial these documents that I just showed you, did you read the documents? Do you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. John, Well, I also have another document before me on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, before we go any further, Mr. John Well, you have a right to have a record made of this proceeding. That is, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a record. You waive or give up your right to have a record. Okay, Mr. John Well, I have before me on the computer a document that is titled Information. This information alleges that on or about September 29th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Mr. John Well, you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. John Well, how do you plead? Guilty, not guilty, no contest. Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's why you pleaded no contest?
Yes, sir.
Actually, that's what no contest means. Now, Mr. John Well, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes.
On page 2 of this same document, there are two sets of initials. First set of initials is below a paragraph that is titled Waiver, and there's on a line next to a word that states guilty. Well, no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment and is next to a statement that reads as follows. I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter or feel guilty in no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of the Defendant's Right of Appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box is checked, states that this is a plea bargaining case, and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. John Well, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. John Well, are you a citizen of the United States?
Yes, sir.
They offer states one.
Now, the state is offering States Exhibit number 1. States Exhibit 1 is the first document that I showed you on the tablet. This is the same document that have your initials in these two locations on page 2 and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? There are no objections. State's Exhibit number 1 will be admitted. Mr. John Well, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
No. Mr. John Well, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 2 days in the Jefferson County Jail with credit for 2 days. And we also ask that those 2 days be applied to court costs along with forfeiture of the weapon to the Jefferson County Sheriff's Department.
Okay. Mr. John Well, the state is offering that you serve 2 days in the Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail because you already served 2 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court cost in this case, what's the court cost? The court cost in this case is $277. You served 2 days in the jail, so $200 is credited toward the payment of the court cost, which leaves a balance of $77. Will you be able to pay that $77 today? Okay. Now, Mr. Shotwell, the state, as part of this plea bargain, is offering that the weapon in this case be forfeited to the Jefferson County Sheriff's Office. And do you recognize this document?
Yes, sir.
This document is titled Motion to Forfeit, and is this your signature on this document?
Yes, sir.
Now, before you sign this document, did you read the document?
Yes.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Shotwell, I'm granting the motion to forfeit the weapon in this case to the Jefferson County Sheriff's Office. Now, Mr. John Well, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. John Well, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. John Well, you're gonna stand next to the bailiff, follow her directions, and you're gonna go downstairs and pay the $77. They're gonna give you a receipt to bring that receipt back upstairs and present it to the court coordinator, and then you'll be free to go. Okay, Louis.
Yes, ma'am.
Send,
It only shows on page.
send, Blunt case back to me. Bradley Michael Blunt. Okay. Mr. Blunt, earlier you entered a plea, well, first of all, you were sworn in. You entered a plea of guilty to the charge of resisting arrest. And you acknowledge State's Exhibit 1, which was a misdemeanor plea admonishments. You acknowledge that your initials was on page 2, your signature was on page 3. You also acknowledge that this trial court certification of defendant's right of appeal. You acknowledge that your signature was at the bottom of that document, and you understood the 2 boxes that was checked at the top. One stated that this was a plea bargain case, you have no right of appeal. And you also acknowledge that because this is a plea bargain case, you are waiving your right to appeal. Is that correct? And you also signed a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. And you acknowledge that your signatures and initials are on that document. And you also acknowledge that the second document, which was a waiver of counsel, which is a waiver of counsel for purposes of entering a guilty plea or proceeding to trial, you also acknowledge that your signature was on that document. Is that correct?
Yes, sir.
Now, the state, in this case, well, you also stated that you're a U.S. citizen and that there is no evidence that you are currently mentally incompetent to stand trial. And the state Well, you also did not object to State's Exhibit number 1. And the state offered that you serve 90 days in Jefferson County Jail. However, that jail time is probated for 1 year. You will require to pay a fine of $300, which court costs of $277. And you will required to pay a probation fee of $6 a month. You're now supposed to pay $15 a month reimbursement fee of $15, and it came to a total of $136 a month. And when the court asks you whether or not you can pay it, you'll say that you'll try to find a way.
I'm on a fixed income.
I know, but I'm just trying to repeat what was said.
Yes, I said I'll figure it out.
Figure it out. Okay. Now, I have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
Okay. And this document was filled out by you, is that correct?
Yes.
Is everything in this document true and correct to the best of your knowledge? Okay. Let's see. Now, the court is going to find that you are indigent. Based on the finding of indigency, okay. Okay. Now, Mr. Blunt, the court is going to find that you're indigent. Based on the finding of indigency, the fine of $300 plus court costs of $277 is going to be converted to community service. It will be converted to 46 hours of community service. Now, the probation fee of $60 a month will be reduced to the statutory minimum of $25 a month. The reimbursement fee of $15 will be waived pursuant to Article 102.018 Texas Code of Criminal Procedure, and you will be required to pay your analysis fee. So your total monthly installments, that is the total amount that you will be required to pay each month, is $44 a month. Will you be able to pay the $44 each month?
Yes, sir.
Now, the 46 hours that was converted from the fine and court costs will be in addition to the 40 hours of community service that the court that you had agreed to. And so it'll be a total of 86 hours of community service. You'll also be required to adhere to the other standard terms and conditions of probation. And do you understand the state's offer?
Sure.
Do you think that the state's offer is fair and just?
Yes.
And do you accept the state's offer?
I do.
Now, the court is going to follow the plea bargain agreement that you've entered into with the state, along with the findings that you're indigent. Now, when you get over to the probation office, Now, is this 86 hours of community service? If you're unable to perform the community service, the probation department will be able to work something out and inform the court, okay? All right, now, just take a seat. We're going to, she has to redo the paperwork to reflect what I just said. And so when she finished with that, she's gonna call you back up and you're gonna follow the directions of the bailiff. All right, you have a blessed day.
Thank you, Your Honor, you too.
All right. Keyshawn Ivory. Yeah. Mr. Ivory, your full name is Keyshawn Jeremiah Ivory. Mr. Ivory, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Ivory, you may put your hand down. How are you doing, Mr. Ivory? Okay, you can't be better than being blessed. Now, Mr. Ivory, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature online as titled defendant? And are these your initials?
Yeah, it's just.
Are these your initials online that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
Now, Mr. Ivory, before you sign and initial these documents, did you read the documents? Do you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Ivory, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your cases is Ryan Matuska. Attorney Matuska will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information, but before she gives you that information, a bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? And I'm going to go over this document with you, and it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol anytime as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, condition number 5 does apply. It says that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Ivory, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, please have a seat in that first chair on the wall and wait for your name to be called. Nicholas Nixon. Mr. Nixon, your full name is Nicholas Nixon?
Yes.
Ms. Nixon, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Nixon, how are you doing? That's good, Mr. Nixon. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And all these your initials on the line that state you'd like to apply for court-appointed attorney. I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Now, Mr. Nixon, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Nixon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Marvel Provo. Attorney Provo will be given information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Once you get the information from the coordinator, you'll be free to go. And you have a blessed day. Now, before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. You see that title?
Sir.
Okay, I'm going to go over this document with you, and it states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or are subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. You understand that condition?
Sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test in the case, the presence of drugs, alcohol, and the defendant body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 states, if defendant is prohibited from possessing firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Mr. Nixon, do you see that?
Yes, sir.
Okay, now do you understand? Now, if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, the warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Please have a seat in the second chair on the wall and wait for your name to be called. We have some forfeitures.
Butler,
Christine,
Iverson,
okay. Christine Michelle Butler was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Christine Butler at the courthouse door. Christine Butler did not answer. Christine Butler has not appeared in court since the court has been in session. Was that Ms. Butler who called this morning?
yes, he said she had a medical.
A medical emergency? Oh, well, okay, what we'll do. She had a medical emergency on this document said
Yeah.
November 5th of 2024. Okay, what we'll do is,
Yes.
oh, she has a warrant out as well? Okay, so we're going to proceed with the bond forfeiture if she provide the proof that's necessary. Yes, okay. So, Ms. Bailiff, the time now is 11:34 a.m. on today's date of December 17th, 2024. Ms. Bailiff, would you please call the name of Christine Butler at the courthouse door?
Christine Butler. No response, Your Honor.
Okay, Christine Butler's name was just called at the courthouse door. Christine Butler did not answer. Reasonable time has passed to give Ms. Butler the opportunity to appear in court. State, do you have a motion? Have a motion be granted. Christine Butler bond will be forfeited and a warrant shall be issued for her arrest. Next case is cause number 24 CCCR 2526, case of style of state of Texas versus Ryan Edward Iverson. Ryan Iverson was scheduled to be in court this morning at 9 a.m. At about 9 a.m. Court's bailiff called the name of Ryan Iverson at the courthouse door. Ryan Iverson did not answer. Ryan Iverson has not appeared since the court has been in session. The time now is 11:35 a.m. on today's date. Ms. Bailiff, would you please call the name of Ryan Iverson at the courthouse door?
Ryan Iverson. Ryan Iverson. No response, Your Honor.
Okay, Ryan Iverson's name was just called to get at the courthouse door. Ryan Iverson did not answer. Reasonable time has passed to give Mr. Iverson an opportunity to appear in court. State, do you have a motion?
State this for bond.
That motion will be granted. Ryan Iverson bond will be forfeited and warrant should be issued for his arrest. And cause number 24 CCCR 2526. Next case is cause number 24 CCCR 2506. Case is style of state of Texas versus Michael Kareem Thomas. Michael Thomas was scheduled to be in court this morning at 9 a.m. At about 9 a.m., Michael Thomas did not answer. The time now is 11:37 a.m. on today's date of December 17, 2024. Ms. Bailiff, would you please call the name of Michael Thomas at the
That name sounds familiar. I received a filing on e-file yesterday, and I believe, Ford Crenshaw filed a letter of representation.
Who is that on?
Michael Thomas.
Yes.
Oh, okay. I'll strike that, so it's gonna be reset, hired.
I believe it was already, I think it was yesterday. It was done after the docket was done.
I received it late afternoon, Judge.
Okay.
I believe.
Brianna Welsh, cause number 24 CCCR 1770. Case and style of state of Texas versus Brianna Rashawn Welsh. Brianna Welsh was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Brianna Welsh at the courthouse door. Brianna Welsh did not answer. Brianna Welsh has not appeared in court since the court has been in session. The time now is 11:38 a.m. on today's date of December 17th of 2024. Ms. Bailiff, would you please call the name of Brianna Welsh at the courthouse door? Okay, Brianna Welsh's name was just called again at the courthouse door. Brianna Welsh did not answer. A reasonable time has passed to give Ms. Welsh an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State this for bond.
That motion will be granted. Brianna Welsh bond will be forfeited and the warrant should be issued for her arrest. And cause number 24 CCCR 1770. Now, you reset Smith, is that correct?
Yes. What about?
Who else? What about Emerson and Thibodeau?
I didn't get. Wife came in here, I don't know what you talking about.
Oh, both of those in jail. Yeah. Yeah, Smith came in, that was, yeah, he appeared. And LeBlanc appeared too. Okay, now this will conclude the calling of the court's arraignment docket. The court will be in recess until 1:30 to resume the trial that we have scheduled at 1:30 this afternoon. Okay.
And also, can we send